Let's call to order the case of Chase Walker versus Newberger Enterprises. Plaintiff, please begin.
Ladies and gentlemen of the jury, first, let me thank you for your time and your service for being here today. Now, I want you to imagine this with me. Imagine that you are a small business owner, an elite leader. You're committed to service. You're a creative. In fact, an award-winning creative. You're a film director. You're sought by the biggest names in the industry. And we all know Atlanta is booming for the film, for music, and for entertainment. In fact, it helps spurs our local economies. Now imagine this. You rent a commercial space to go on, to conduct business, to be able to cater to these high-class clients that you have. But you slowly begin to engage with your landlord, and your landlord is actually owned by a family. The property that you lease is owned by a family. Well, how about this? One day, you find your landlord snoozing in your office, going and ruffling through your papers, acting as if they were letting in a cleaning vendor, but they're in your secretary's office.
Objection, Your Honor, this is argument, not open statement.
Yes, counsel, you can talk about what you expect the case to present, but not argument, please.
I'll restate, Your Honor. Harassment is not lawful management. And that's what this case is about. You're going to hear case facts about an overzealous property manager who has gone to the extent of sneaking into private events, hoping to dupe security, and even causing fights with my client's client and customers on the premises in which his office is located. But that's not even the icing on the cake. You're also going to hear how that same property manager even attempted to conceal her actions by messing with the tapes. Can you imagine how difficult it is? Can you imagine getting a call from a client saying, hey, I don't want to work with you anymore because my car just got towed and I was coming to do business with you and I just parked in a sign that says visitor parking allowed? Can you imagine how difficult it is?
Objection, this argument, Judge.
Ma'am, I'm gonna sustain the objection. You have to stay away from the arguments. Ladies and gentlemen of the jury, what the counsel is saying are just evidence that it's not part of the case until the case is actually presented.
Ladies and gentlemen of the jury, I'll keep it simple and I'll keep it short. You're going to hear the case and you're going to hear a lot of different facts. But one thing that I want you to keep in mind, harassment is not lawful management.
Defense?
Thank you, Your Honor. Ladies and gentlemen, I'm tempted to start out once upon a time because this whole case is a fairy tale. And what the plaintiff has said is not going to be proven at court. Now, what you're going to do is you're going to listen to the facts, you're going to judge the demeanor and the credibility of every witness. At the end of the case, the judge is going to tell you what the law is. Not counsel, not me, the judge. And then you're going to take the evidence that you heard in court and only what you've heard in court, apply it to the law, and render a verdict. And the evidence is going to show that the plaintiff here doesn't even have a cause of action at law, that they've sued for harassment, and that tort, which is a civil wrong, doesn't exist in the state of Georgia. It doesn't exist. And I have questions which are going to show you that even if it did exist, all that we did as the enterprise, the landlord, is enforce the rules that are in the lease that he signed. From the day that he got in there, he's violated the lease. The put in
Objection,
equipment.
Your Honor. Argumentative.
Counsel, good for the gander, good for the goose. Please, no arguments.
I expect the evidence to show that all of the interactions between him and the landlord were because of his violation of the rules, which affected the safety of every single tenant in the building.
Objection, Your Honor. He's causing them to form improper opinions.
Counsel, stay away from opinions. This is just only opening arguments.
I expect that you will conclude from the evidence that he's coming into this court without clean hands, and the judge is going to charge you on that and tell you that if you're going to sue somebody, you can't set it up, have dirty hands, and then
Objection, Your Honor. Dirty hands, unclean hands.
I'm gonna sustain.
That's the law, Judge.
I'm gonna sustain the objection.
The evidence is going to show that this entire enterprise, the entire conflict, is because he won't follow the rules. That's it. And at the end of this case, I expect you're going to apply the law to the facts and find in favor of the defendant. Thank you.
All right, thank you. You can call your first witness, Plaintiff. Call your first witness, Plaintiff.
Yes, Your Honor. We would like to actually call Miss Bethany Newberger Williams to the stand, Your Honor.
Are you calling up for the purpose of cross-examination?
Absolutely.
Ms. Newberger, take a stand, please.
Raise your right hand. You swear or affirm that the evidence you're going to present to the court is the truth, the whole truth, and nothing but the truth?